Hello everyone, my name is Wendy McLean and I'm a program lawyer with the Continuing Legal Education Society of BC. On behalf of CLEBC and the Law Society, co-sponsors of today's course, we'd like to welcome you all to today's session on the new Code of Professional Conduct for BC lawyers. This is part 2 of our conduct series, and today's session will focus on the lawyer's relationship to justice, the Law Society, and others, as well as the business of law. To get the full benefit of today's program, you should have in front of you a copy of the code and the reference sheet. A link to both of those sets of materials was sent out in your sign-in instructions. For those of you who missed part 1 or are looking to review the information covered in part 1 or in this session, a link to that recording will be available in the next several weeks, and information on how to access that link will be sent out in one of the Law Society's regular communication pieces. So watch for that. It'll be coming soon. After this introduction, we will be running a segment that we had previously taped. We taped it so that we could ensure that we covered all of the information properly and to allow us to organize some meaningful answers to your questions. In order to do that, we will ask you to type in your questions as soon as you possibly think of them into our chat feature, and we will try and group like questions together and get as many answers to your questions as we can out for you today. Since there are approximately 1,300 of you watching today, we may not get to every question. We will do our best, and as I say, we'll try and link like questions together. However, if you don't get your question answered, if you have follow-up questions, or if you have practice-specific information that you would like to get, please don't hesitate to contact one of our practice advisors after today's session. Now I'm pleased to introduce our 2 presenters for today, Gavin Hume and Barbara Buchanan. Gavin Hume QC likely needs very little introduction. He practices with the firm Harris & Company here in Vancouver, but most of you will know him as a past president of the Law Society and a life bencher. He's currently a member of the Law Society's Ethics Committee, is a Law Society's representative on the Federation Council, and most importantly for today's session, chair of the Federation of Law Society's Standing Committee on the Model Code of Professional Conduct. Also joining us today is Barbara Buchanan. She has been in private practice, acted as an adjudicator, and has been in-house counsel of a corporation. She currently works as one of the practice advisors with the Law Society of BC. All right, now let's dive into some of the substantive issues with the new code. In part 1 of the course, we covered some background about how we came to have a new code. Gavin, can you just fill us in for those who weren't able to join us in part 1?
Certainly. The BC Code comes from the Model Code of Professional Conduct developed by the Federation of Law Societies of Canada. The 14 law societies in Canada are all members of the Federation. In 2002, the Federation entered into the first of 4 mobility agreements, which permits lawyers in the common law provinces to move essentially freely between the provinces. Similar agreements cover the Law Society lawyers in the territories and Quebec. The need for a standard code across the country was driven by mobility, but also by such factors as media scrutiny and, most importantly, the desire to maintain self-regulation of the profession. The Federation's goal was to synchronize as much as possible the ethical and professional conduct standards across the country. So far, a version of the Model Code has been implemented in BC, Alberta, Saskatchewan, Manitoba, Nova Scotia, and Newfoundland and Labrador. Essentially, all of the other law societies are actively working on it. The result is the new BC Code, which is substantially based on the Federation's Model Code, with some changes thought necessary for British Columbia. Development of the Model Code will be an ongoing process of change. The Federation appointed a standing committee in 2010. Its purpose is to review changes in the law, changes made by law societies, and suggestions coming from law societies with a view to making suggestions for amendments to the Model Code to the Federation Council. Changes to the BC Code will also be an ongoing process of revision and consultation, as was the case formerly with the Professional Conduct Handbook. But it will now include making representations to the Standing Committee with respect to changes that the Ethics Committee in BC considers desirable. The Professional Conduct Handbook is no longer in effect as of the 1st of January 2013.
Thank you, Gavin. Barbara, can you tell us generally how the new code differs from the handbook?
Yes, I'd be happy to do that, Wendy. We're excited to have the new BC code in BC, although it's going to take us a bit of time to learn it and become familiar with it. Most of the basic principles, however, in the BC code are the same as they were in the handbook. Some differences were highlighted in part 1 of the course, and we will highlight some other differences today in part 2. The code, like the handbook, is a guide to ethical duties and standards for lawyers. But of course, there are always common law principles and rights that also come into play. There is a table of concordance available on the Law Society website, and which you should have received through your registration today, so you can look up a former handbook rule and see if the corresponding rule, if there is one, is in the BC code. Physically, the code looks different from the handbook. The code consists of a table of contents, 7 chapters, with sections, rules under the sections, and commentary to the rules. Sometimes the commentary is 1 paragraph or maybe several paragraphs in length. There are also 5 appendices A to E. You'll notice that there is a different numbering system than in the handbook. The commentary is part of the rules, and it provides interpretation of a rule's meaning and sometimes includes examples. Our personal views are that the rules and the commentary are of equal weight. However, we will anticipate that this will be considered by the Ethics Committee in the first half of 2013, and we will hear what the Ethics Committee has to say on this point. 4 of the 5 appendices have been basically incorporated from the appendices to the handbook, and so will already be familiar to you. As a result of the new Family Law Act, which will be proclaimed on March 13th, 2013, changes to Appendix B regarding family law mediation were approved at the January Ventures meeting to include rules about the obligations of family law mediators, arbitrators, and parenting coordinators. The annotations that formed part of the online version of the Professional Conduct Handbook will remain on the Law Society website as an historical document. The annotations are also migrating to the online version of the code. Annotations are an ongoing process, so lawyers will need to consider whether a particular annotation, formally related to the handbook, is still valid, having regard to any new language in the code. So remember that you can use the table of concordance to compare handbook language to code language. For the most part, the annotations are Ethics Committee opinions, and to a lesser extent, Law Society discipline decisions and court decisions. Chapter 1 is an interpretation and definition chapter that contains definitions that are used throughout the code. To help with our discussion today, please consider the following terms. First, client has an expansive definition. A client includes anyone who consults a lawyer and reasonably concludes that the lawyer has agreed to render legal services. A lawyer-client relationship may be established without formality. Disclosure is another important defined term. It means full and fair disclosure of all information in sufficient time for a person to make a genuine and independent decision and the taking of reasonable steps to ensure understanding of the matters disclosed. Consent means fully informed and voluntary consent after disclosure, with some written requirements for the lawyer to fulfill. Finally, law firm is widely defined. It includes 1 or more lawyers practicing in a sole proprietorship, in a partnership, as a clinic under the BC legislation governing legal aid, in a government, a crown corporation, or any other public body, or in a company or other organization. Well, I forgot I wanted to mention another definition, tribunal. Tribunal includes a court, board, arbitrator, mediator, administrative agency, or other body that resolves disputes regardless of its function or the informality of its procedures.
Thank you both for that overview. Now let's get into a few more details and specifics on the code. Barbara, what does the code have to say about fees and disbursements? Is there anything new on this front?
Yes, there are some new provisions. Section 3.6 includes new provisions regarding fees, disbursements, other charges, and that's with a capital O, capital C, and interest. They include a writing requirement, a list of 11 factors that may be appropriate to take into account in determining what is a fair and reasonable fee, a distinction between disbursements and other charges in statements of account, commentary about charging interest, and special provisions regarding contingent fee agreements. Rule 3.6-1 contains the basic statement of a lawyer's duty. A lawyer must not charge or accept a fee or disbursement, including interest, unless it is fair and reasonable and has been disclosed in a timely manner. Obviously, where aspects of fees, disbursements, and interest are covered by statutory provisions, law society rules, or rules of court, those will govern. Paragraph 1 of the commentary to Rule 3.6-1 sets out in letters A to K 11 factors that may be taken into account in determining what is a fair and reasonable fee. To name just a few, these would include the time and effort required and spent, the difficulty of the matter and the importance of the matter to the client, any relevant agreement between the lawyer and the client, any estimate or range of fees given by the lawyer, and the client's prior consent to the fee. Paragraph 3 of the commentary to Rule 3.6-1 says that a lawyer should provide to the client in writing, before or within a reasonable time after commencing a representation, as much information regarding fees and disbursements and interest as is reasonable and practical in the circumstances, including the basis on which fees will be determined. We'd like to highlight the reference to interest in the commentary. A lawyer may only charge interest if it is fair and reasonable and it is disclosed in a timely fashion. So if a lawyer wishes to charge interest on an overdue account, the lawyer should set out in the retainer agreement the rate and how interest will be calculated. This isn't really anything new, but it's now in the code. We'd also like to highlight what the code says may be charged as fees, disbursements, and that capital O, other, capital C charges in a statement of account. Rule 3.6-3 requires that a lawyer must clearly and separately detail the amounts charged as fees and disbursements in a statement of account delivered to a client. The two main categories of charges in a statement of account are, of course, fees and disbursements. Paragraph 1 in the rules commentary sets out what a disbursement is. It says that a lawyer may charge as disbursements only those amounts that have been paid or are required to be paid to a third party by the lawyer on a client's behalf. So some examples of disbursements that a lawyer might commonly pay to a third party on a client's behalf could include long-distance phone charges, postage, courier charges, experts charges, computerized legal research charges, government filing fees, transcript charges, hotel charges, and out-of-office photocopying and printing. Notice that the code makes a clear distinction between disbursements and what it refers to as other charges in paragraph 1 of the commentary to Rule 3.6-3. The commentary says that a subcategory entitled Other Charges may be included under the fees heading if a lawyer wishes to separately itemize charges such as paralegal, word processing, or computer costs that are not disbursements, provided that the client has agreed in writing to such costs. Assuming that a client has agreed in writing to such costs, reasonable in-house photocopying and fax charges, a file opening fee, flat rate quick law search charges, and deliveries which cannot be charged as disbursements could be included under the subcategory Other Charges. We recommend that lawyers provide clients with a written retainer agreement either before taking the case or early in the relationship. A sample general retainer agreement is on the Law Society website for lawyers to consider when drafting a retainer letter. This is not meant to be a standard letter that's going to work for every situation. Its suitability will depend on a number of factors, including writing style, a lawyer's needs, the client's needs, and current law and practice in any particular area. The Trust Assurance Department is preparing a sample statement of account as another resource that you'll be able to find online in the future. Keep in mind that Rules 3.6-9 requires that if a lawyer and client agree that the lawyer will act only if the lawyer's retainer is paid in advance, the lawyer must confirm that agreement in writing with the client and specify a payment date. I think that's enough on that for now, Wendy.
All right. So Barbara, what if something unforeseen happens that may substantially affect the fees or disbursements on a file?
Okay, well that's a good question. In that case, the lawyer should immediately explain to the client about any fees or disbursements that the client may not reasonably have been expected to anticipate. This should be followed up in writing, as should all fee discussions that occur as a matter progresses. A lawyer may, of course, revise the initial estimate. This is covered in paragraph 4 of the commentary to Rule 3.6-1.
And Barbara, you wanted to say something more about contingency fee arrangements?
Oh yes, I sure did. A big red flag. So if I put you to sleep, wake up. This is important. There is a conflict between Section 67 sub 2 of the Legal Profession Act and paragraph 1 of the commentary to Rule 3.6-2. Section 67 sub 2 of the Legal Profession Act says that a contingent fee agreement must not provide that a lawyer is entitled to receive both a fee based on a proportion of the amount recovered and any portion of an amount awarded as costs in a proceeding or paid as costs in a settlement. That is, you can't receive both a fee and costs. It's only one or the other. And there doesn't seem to be a provision in the Legal Profession Act to apply for judicial approval to receive both. So, accordingly, it appears to conflict with paragraph 1 of the commentary to the Code Rule 3.6-2 that a lawyer and a client may make an agreement that, in addition to the fee payable under the agreement, an award of costs or costs obtained as part of a settlement is to be paid to the lawyer. The Ethics Committee has reviewed this and will likely refer it to the benchers for modification early in 2013. If there is an agreement that the lawyer will be entitled to an amount awarded as costs, paragraph 2 of the commentary to Rule 3.6-2 makes it clear that the lawyer is obliged to disclose the costs to the client. As with any of the code rules, keep in mind that there may be relevant provisions in the Legal Profession Act, the Law Society rules, or court rules. Both the Legal Profession Act and the Law Society rules have specific provisions regarding contingent fee agreements.
Gavin, what about dividing fees and referral fees? Is that permitted? And can a lawyer give someone who isn't a lawyer a referral fee for referring clients?
I'd certainly like to comment on that. Rule 3.6-4 provides that if a lawyer acts for 2 or more clients in the same matter, the lawyer must divide the fees and disbursements equitably between them unless the clients agree otherwise. But what about dividing fees between lawyers who aren't in the same firm? Rule 3.6-5 provides that if the client consents, and as we have said earlier, remember that there's a writing requirement for consent, fees for a matter may be divided between the lawyers who aren't in the same firm, provided that the fees are divided in proportion to the work done and the responsibilities assumed. Rule 3.6-7 says that a lawyer must not either directly or indirectly, share, split, or divide his or her fees with any person other than another lawyer, or give any financial or other reward to the referral for the referral of clients or client or clients' matters to any person other than another lawyer. If a client refers a matter to another lawyer because of the lawyer's expertise and the referral wasn't made because of a conflict, Rule 3.6-6 permits a lawyer to pay a referral fee to another lawyer, provided that the fee is reasonable and doesn't increase the total amount of the fee charged to the client. In addition, if it requires that the client is informed and consents, and that the other lawyer is a member of a recognized legal profession, and the other lawyer is acting in compliance with the law and any rules of the legal profession in the other lawyer's jurisdiction. In the case of dealing with non-lawyers, Rule 3.6-7 provides that a lawyer must not enter into any arrangement to compensate or reward someone who isn't a lawyer for referring clients and may not directly or indirectly share, split, or divide legal fees with a non-lawyer. Now, sometimes lawyers ask about entertaining potential referral sources, for example, a referral source from a realtor. On a small scale, this is permitted, and there is helpful information in the commentary to Rule 3.6-7 about this. For example, a lawyer may occasionally entertain potential referral sources by purchasing meals or providing tickets to activities such as sporting or musical events without contravening the referral fee rule. Under Rule 3.6-8, multidisciplinary partners, or MDPs as we call them, are an exception to the prohibition against sharing fees with non-lawyers. If a lawyer has been permitted by the Law Society to practice in a multidisciplinary partnership or in an NDP relationship, a lawyer may share fees, profits, or revenues from the law practice with a non-lawyer member of the NDP. This is on the basis that all of the MDP owners are individuals or professional corporations, as that term is defined, actively involved in the MDP's delivery of legal services to clients or in the MDP's management. The MDP's rules that were in the Handbook have been preserved in the Code in Rule 3.6-8, and there isn't really anything new about MDPs. Practicing lawyers who are members of an NDP must have actual control over the delivery of legal services by the MDP. The terms MDP and professional corporations are defined also in the Law Society rules, and there are a number of other Law Society rules that specifically deal with MDPs that can be found in Rules 2-23.1 to Rule 2-23.12. The Law Society Member Services Department handles all applications for multidisciplinary partnerships.
All right, thanks, Gavin. Now, in relation to reasonable fees and disbursements, the code says that someone other than the client may provide compensation to a lawyer with the client's consent. What's that about? When we were talking about referral fees right now, I thought it was pretty clear that a lawyer could not receive a referral fee from a non-lawyer.
Yep, that's certainly correct. Paragraph 2 of the commentary to Rule 3.6-1 provides that fees, rewards, costs, commissions, interest, rebate, or other compensation related to the lawyer's professional services provided on behalf of the client can only be taken by the lawyer if, first of all, there is a full disclosure to the client. Secondly, the client consents in writing, and in addition, in the circumstances are permitted in the code. A lawyer's duty of candor, a duty that is part of the lawyer and client fiduciary relationship, requires there be no hidden fees. Mr. Justice Binney, in Regina versus Neal in 2002, discusses the duty of candor with respect to matters relevant to a retainer, and fees, in our view, are relevant to the retainer. Now, as I said, referral fees are not permitted between lawyers and non-lawyers. However, there are some circumstances outlined in paragraph 2 of the commentary to Rule 3.6-1 where a lawyer may receive fees or costs from another party. Those circumstances include an agreement with the client that the lawyer will be paid the costs awarded in a proceeding by the other party rather than receiving a fee from the client. Other circumstances include where a lawyer is acting for an institutional lender, and the agreement between the lender and the borrower may be that the borrower has the responsibility to pay the lawyer's legal fees related to a loan agreement. Another circumstance arises when a lawyer's fees are being paid by a legal aid agency. Now, whatever the case, a lawyer may not accept any fee or any kind of compensation that is hidden from the client. The fiduciary relationship that exists between lawyers and clients requires, as a result of the duty of candor, full disclosure.
Now, Gavin, is this a good time to talk about withdrawal? I know that lawyers sometimes withdraw because they haven't gotten paid.
Yes, sometimes lawyers withdraw because they haven't been paid. They also withdraw because of ethical reasons, or where there's been a serious loss of confidence between the lawyer and the client. The withdrawal rules are set out in about 6 pages of the code, starting at section 3.7, and much of the content is the same or similar to chapter 10 of the handbook, although the lawyer leaving a firm rules that were in chapter 3 of the handbook are also incorporated in section 3.7. There are a number of key points, and some of those are as follows. A lawyer must not withdraw from representing a client except for good cause and on reasonable notice to the client. And generally, a client should be given sufficient time to retain and instruct replacement counsel. Now, turning to contingency fee agreements, special circumstances apply to withdrawing when there is a contingency fee agreement. In this regard, see paragraph 2 of the commentary to Rule 3.6-2. A lawyer has impliedly taken the risk of not being paid if the lawsuit is unsuccessful. As a result, and accordingly, unless the contingency fee contract specifically states that the lawyer has a right to do so and sets out the circumstances under which that may occur, a lawyer cannot withdraw from representation for reasons other than for the reason where a lawyer is obliged to withdraw. The situation where a lawyer is obliged to withdraw are set out in Rule 3.7-7. A lawyer is obliged to withdraw, first of all, if he's discharged by the client. Secondly, if the client persists in instructing the lawyer to act contrary to the professional ethics that govern the profession, or if the lawyer isn't competent or doesn't have the skills to continue to handle the matter. While it's not mentioned in Rule 3.7-7, of course, a lawyer must withdraw if there's a conflict that cannot be overcome. There are also specific rules about withdrawal from criminal proceedings for non-payment of the agreed fee or for other adequate cause stated in Rule 3.7-4. And we urge lawyers who practice in the criminal law field to read those rules, and it discusses the case authority that's relevant.
Thanks, Gavin. Nobody likes to have to withdraw, but if you do, it's nice to have some guidance to do so.
Well, sometimes we're happy to withdraw.
You know what, that's true too. Sometimes you can't wait to get off the case. Now, Barbara, sticking with the business theme, is there anything new in the code about marketing?
Well, Wendy, I'm happy to tell our audience that there really isn't anything new. So if you know the marketing rules, you're in good stead. If you haven't reviewed them for a while, you should. Chapter 4 of the code deals with the marketing of legal services, and apart from the renumbering, the content is basically the same as in Chapter 14, the marketing chapter in the handbook. The benchers and the Ethics Committee concluded an extensive review of the handbook's marketing rules back in 2009 and approved amendments at that time, so those rules were maintained in the code. The marketing rules apply to any marketing activity in which the lawyer is identified as a lawyer, or a mediator, or arbitrator. Marketing activity is a defined term and has the same definition that was in the handbook. So marketing activity includes any publication or communication in the nature of an advertisement, promotional activity or material, letterhead, business card, listing in a directory, a public appearance, or any other means by which the professional legal services are promoted or clients are solicited. Rule 4.2-5 says that any marketing activity undertaken or authorized by a lawyer must not be false, inaccurate, unverifiable, misleading, or contrary to the best interests of the public. A marketing activity may violate the rule if it is calculated or likely to take advantage of the vulnerability, and that can be either physical or emotional, of the recipient, is likely to create in the mind of the recipient an unjustified expectation about the results the lawyer can achieve, or otherwise brings the administration of justice into disrepute. An example of something that could bring the administration of justice into disrepute might be a lawyer suggesting that the lawyer or law firm has an improper influence with former members of the firm who are now judges or holders of political office. Rule 4.3-01 says that a lawyer may state in any marketing activity a preference for practice in any fields of law if the lawyer regularly practices in each field.
Thank you both. This brings us to the end of our discussion on the business of law. We'd like to take a few moments to answer your questions right now, but if perchance we don't get to your questions, we'd like to remind you that after the course you are welcome to contact a practice advisor for a one-to-one consultation on a confidential basis, and we'll now move to our question period. So the first one is, Gavin, do you think that changing from the handbook to the code will make any difference to the way ethics is practiced in BC?
Yes, I think it will. I think the Law Society and the benchers think it will make a significant difference. The handbook did not have the same amount of commentary, discussion with respect to how the rules will apply. I think the model code, the BC Code of Professional Conduct, does a much better job of explaining the ethical obligations that lawyers have. The Law Society practice advisors receive approximately 6,000 inquiries a year with respect to these sorts of topics, and I think they are going to find, and I think the profession will find, that the commentary and the current structure and the detail that's provided in the model code will be of great assistance. In the long term, I think it's also going to be of great benefit because the law professors are now going to be required to teach ethics as a part of the education of our law students. And I know from talking to many of the ethics profs from various law schools across the country that they intend to teach the Federation's model code, which is essentially the same as the BC model code. So over a period of time, in addition to the fact that it's going to be a benefit to the current practitioners, we'll have a group of lawyers coming to us, a group of students coming to us who will become lawyers, who will be very well educated, in my view, in their ethical obligations.
Thanks, Gavin. That was really helpful. So Barbara, I've got a question for you. Is it true that it's a requirement that lawyers must always have a written fee agreements with their clients?
Good question, Wendy. No, lawyers don't. It's not mandatory that lawyers always have a written fee agreement with their clients, except with some exceptions, which are set out. You'll see there's some shoulds in the code, and there are some musts. There are certain situations where it's a must, and that's something that hasn't changed, and that's when there's a contingent fee agreement. That's because there's a Law Society rule that says that there must be a written contingent fee agreement. Something new is billing for other charges that are not disbursements. Must get the client's consent, and consent has a writing requirement. Another circumstances that comes to mind is when the lawyer is taking compensation from someone other than the client. There's a rule about that. That would be in writing. There's a requirement that if you're paying referral fee to another lawyer, that must also be in writing. There might be more, but I can't think of anything else right now. It's always, of course, a good idea to have a written agreement because it saves misunderstandings and problems later on. Thanks, Wendy.
Thanks, Barbara. I have another one. We've got quite a few questions online about the PST. How will other charges be treated for tax purposes once the PST is back in effect, Barbara?
Well, we don't know how the province will decide to treat other charges that aren't disbursements. It's other charges, for the most part, like fax charges, or if some firms, for example, charge a file opening fee. Those don't really fit within the definition of the practice of law, but you know, they may or may not be taxable. We'll just have to wait and see. The regulations aren't out yet.
All right. With respect to the new code section 3.6-3, do law firm management companies qualify as third parties for the purposes of billing disbursements? That is, can a management company bill the firm for things such as photocopies so that those can be still charged as disbursements, or do they have to move them into the fee section of other charges? Barbara, what do you think?
Well, in my view, no. See what Gavin has a different view, but I think that's part of the duty of candor, and they're not at arm's length. You know, it's a company that the firm has set up, presumably specifically for that purpose. Maybe other purposes as well, but you know, it's all part of transparency and the duty of candor.
And I would agree with that. The issue of candor is something that is fundamentally important. The Supreme Court of Canada has commented on that on at least one or two occasions. The nature of your fees to the client, it fits within that obligation of being candid with the client. We've received a number of questions online today with respect to this issue of other charges, and I think the simple answer is that it's part of your duty of being candid with the client, part of your obligation to explain to the client the nature, all aspects of the retainer, which includes fees.
All right. So the next question is, we employ a legal assistant and bill her time spent on certain electronic document production projects on an hourly basis, the same way we do as our legal fees. Is this acceptable under the Code Section 3.6-3? The commentary to that section seems to suggest that paralegal charges must be separated into an other charges category. Gavin, what do you think about that?
I think it has to go into the other charges category. Again, it's part of the duty of candor. It is a separate charge. It's not a charge for a legal service, and so I think it fits under the other disbursements category.
Thank you. I know that's a common one that might come up. I have another question that says, in a normal contract of purchase and sale, funds can be tendered by way of a lawyer's trust check. Certain large downtown firms require non-Vancouver firms to certify their trust checks. Does the code say this is permissible or not? Comments? Barbara, what do you think?
I think that you're referring to the Rule 7.2-12, starting at the bottom of page 87 of the code. That language is identical to the language that was in the Professional Conduct Handbook. And if you recall, there was a footnote that came out of an ethics committee opinion, that's my recollection, about this issue. And the old footnote, I happen to have the handbook with me, so I can read out what it says. It says, unless funds are to be paid under an agreement that specifically requires another form of payment or payment by another person, a lawyer must not refuse to accept another lawyer's uncertified check for the funds. It is not improper for a lawyer at his or her own expense to have another lawyer's check certified. So I think that answers your question. You can ask your friend to have the check certified. It's all right to ask. They don't have to. If you want it certified, then you should be paying for it, if that's not part of the contract.
Thank you. So the next question is, can a client waive the requirement to distinguish disbursements from all other charges? Gavin, did you have comments on that?
I think not. I think the ethical obligation is spelled out both in the rule or in the commentary. Our view is that the commentary and the rule has the same weight. And it, as a result, means that you have to deal with it as described in the commentary and that it can't be waived by the client.
Thanks, Gavin. This isn't one that often comes up. Can lawyers still provide a free 30-minute consultation under the new definition of client? It says often free consultations are provided to determine if the lawyer wants to take the retainer.
Right. And I think the answer to that question is yes, but the lawyer has to worry, as was the case before, with respect to receiving of confidential information, the need to protect that confidential information, the risk that a conflict will arise as a result of that free consultation. So the answer to the question is yes, you can continue to provide that free 30-minute consultation, but as it was before, you could get yourself into a situation where you've received confidential information that you can't share, and it may create a conflict such that you'll be precluded from acting from another party that comes in with respect to the same issue. So nothing really has changed. I think it's just clear that you can develop, in effect, a solicitor-client relationship as a result of those more informal opportunities.
All right, so another question came up in terms of disbursements and other charges. There seems to be a little confusion over what falls into where. If a lawyer incurs travel expenses at the client's request, such as airline tickets, hotels, accommodation, meal expenses, etc., are those charges disbursements or other charges?
Those charges are disbursements. The client would be paying the hotel, so paying a third party for the accommodation. There'd be a bill, and that's clearly a disbursement.
All right. We had a series of questions that dealt with jointly representing clients. So if you were jointly representing clients and one client agrees to pay, do you still need to split the bill between them? Gavin?
I think the answer to that question is no, you don't. There's obviously an understanding or an agreement as to how it's going to be paid. You probably have an obligation to provide a copy of that bill to the other client, but my view is that you don't have to split the bill. One of the two jointly represented clients has agreed to pay, and that's the way the bill should be rendered.
All right. So there was another one that said, is there any change in what obligations an employer has to report a potential breach of the code by an employee lawyer to the Law Society?
The answer is yes. The rule that deals with the obligations to report does elaborate on those circumstances where reporting has to occur. So the answer with respect to lawyers employed by a law firm or by a partnership, there is an expanded obligation under that rule.
All right. In the handbook, there was a rule that a lawyer must not endorse or lend his or her credibility as a lawyer to the promotion or advertising of any product, property, investment, or service for sale to the public with very limited exceptions. I can't read today. I can't find that rule in the code. Is there one?
That exact rule hasn't been replicated in the code. It actually used to be in the marketing section of the handbook, and then it was moved to another section, I think in chapter 4 of the handbook. We feel that now, however, the marketing rules in the code, for the most part, look after that. As well, there's some other sections regarding outside interests in the practice of law, communication with the public, that may also come to play depending on the facts. Gavin, did you have anything to add to that?
Well, I think you're right. We rewrote the marketing rules in 2009. We made them much more liberal, and so that they're not as restrictive as they historically have been. We took out that particular provision and, as you said, moved it into what used to be Chapter 4 of the handbook. And I think for guidance, one just looks at the marketing rules now as opposed to relying on the old handbook.
All right, I have another question that says, on the subject of referral fees, can I pay a referral fee to a non-lawyer in my firm? Gavin?
I don't think you can pay a referral fee to a non-lawyer in your firm, but you can certainly provide compensation to members of your firm based on the results that the firm has achieved during the course of the year, the profits that are achieved. So no specific referral fee, but you can certainly provide, in my view, incentive compensation based on how well the firm's done during the course of a year.
All right, there seems to be several questions about retainer agreements. So if you have a retainer agreement already in place with your client, do you need to change the retainer agreement or revise it or replace it with the new distinction required with other charges and disbursements, etc.?
I think the answer to that question is, again, no. Going forward, obviously with new retainer agreements, you should spell out the nature of the charges you're going to provide, but I think it would be adequate under the circumstances just to revise your bill to reflect other charges and disbursements the way the BC Code requires.
Thank you for that. Now, I know that we didn't get to a lot of the questions that were asked. It's not that we're trying to avoid them. There's just so many that we can't possibly answer all of them at this time. I would like to remind you that if you did not get your question answered, please do contact a practice advisor with the Law Society, and they would be happy to walk you through it. Now, in order to get through the rest of our substantive material, I think we need to go on to the next section. We will now switch our focus to a lawyer's relationship to the administrative justice, the Law Society, and others. Chapter 5 deals with the lawyer's relationship to the administrative justice and contains a pile of information. Now, Gavin, what would you like lawyers to know about this issue, and in particular, Chapter 5?
Well, before we move to Chapter 5, which, as you've indicated, is headed the relationship of the administration to the relationship of justice, it bears mentioning that there is a new rule that a lawyer must encourage a client to compromise or settle a dispute whenever it is possible to do so on a reasonable basis. This is set out in Rule 3.2-4 of Chapter 3. A lawyer must also discourage a client from commencing or continuing useless legal proceedings. The commentary to the rule in the paragraph 1 says that a lawyer should consider the use of alternative dispute resolution, or ADR as we call it, whenever appropriate, and inform the client of ADR options. If so instructed, a lawyer should take steps to pursue alternative dispute resolution. Now, I'd like to tell you about Chapter 5, the relationship to the administration of justice. I'd recommend that anyone who intends to appear before a tribunal to read Chapter 5 thoroughly. Rules 5.1-1 says, and I quote, "When acting as an advocate, a lawyer must represent the client resolutely and honorably within the limits of the law, while treating the tribunal with candor, fairness, courtesy, and respect." The rule applies not only to court proceedings, but also to proceedings before boards, administrative tribunals, and before others who resolve disputes, regardless of their function or the informality of their procedures. I know that this is a matter of concern to the Labor Relations Board and the Human Rights Tribunal, who are deserving of the same courtesy and respect as the court. This is made clear in the Code through the definition of tribunal and Rule 5.1-1. In addition, Chapter 5 provides good guidance for any type of advocacy. Certain areas of advocacy are particularly highlighted. They include the special duties of defense counsel and prosecutors, including guidelines for entering an agreement on a guilty plea covered in Rules 5.1-1, 5.1-3, 5.1-7, and 5.1-8. There are specific rules regarding lawyers as witnesses found in Rule 5.2-1. And that really says that a lawyer should not express personal opinions or belief. This means that a lawyer should not, in effect, appear as an unsworn witness or put the lawyer's own credibility in issue. There's nothing new about that. There are also rules regarding communications and relations with jurors. In addition, Rule 5.5-2 provides that lawyers have a duty to disclose information in their possession that suggests that a juror may be illegally disqualified for serving.
All right, Gavin, what does a lawyer do if they discover that they have done something in breach of one of these advocacy rules?
Yes, Rule 5.1-4 provides that a lawyer who discovers that he or she has done or failed to do something that would have been a breach of the advocacy rules must, subject to the confidentiality rules, disclose the error or admission and do all that can reasonably be done to rectify the problem. If a client desires to follow a course that would involve breaching the advocacy provisions, the lawyer must refuse and do everything possible to prevent it. If the problem cannot be solved, the lawyer should withdraw, subject obviously to the withdrawal provisions in Section 3.7, or seek leave to withdraw.
Gavin, can you give us an example of something that a lawyer would need to disclose?
Certainly. For example, if a lawyer mistakenly failed to disclose binding authority directly on point, or if the lawyer mistakenly misstated the content of a document, the lawyer must bring it to the attention of the court or the tribunal and the opposing counsel. I happened to be in the Supreme Court of Canada observing a case last week, and the counsel for one of the parties misstated a part of the pleading. During the break, he realized that, and his first comments after the break were to correct that misstatement. So it's obviously an obligation we've had for some time, and it's reinforced in the rule.
Gavin, what does the code have to say about communication with witnesses and giving evidence?
Yeah, well, I'd like to bring your attention to the new rules with detailed guidelines, which we didn't previously have, though we followed these rules, many of these rules, for lawyers with respect to communicating with a witness, giving evidence in a proceeding, and during examinations for discovery. They're in Rule 5.4-2. For example, during a cross-examination of a lawyer's own witness, the lawyer must not discuss with the witness the evidence the witness gave in chief or relating to any matter introduced or touched upon in chief. Upon the conclusion of cross-examination and before any re-examination, a lawyer may discuss any matter with the witness with leave of the court. Rule 5.4-2 sub D is a new rule that all lawyers who conduct examinations for discovery should read. It sets out the guidelines for when a lawyer may discuss with a client the evidence the client has given or will give on an examination for discovery. Counsel should not discuss discovery evidence during a break, except in the limited circumstances set out and identified in that rule. There are also guidelines about adjourning an examination and interruptions. There is, in my view, a very useful discussion of the issues relating to counsel speaking to a witness during an examination for discovery in an article by Mr. Shields and Mr. Chapray, and that article is called Woodshedding, Interruptions and Objections, How to Properly Conduct and Defend an Examination for Discovery. That can be found in The Advocate in September 2010 edition. You find the information about how to locate the article in paragraph 8 of the commentary at page 68 of the code. Page 68 also refers to a BC Supreme Court case and an Ontario case regarding these issues. Those are the Fraser River Powell case and the Iroquois Falls decision. The case citations are also on page 68 of the code.
All right, now let's turn to the next part of the code, Chapter 6, which deals with a lawyer's relationship to students, employees, and others. Gavin, where should we begin?
Well, we should start with the fundamental principle about supervision, which is found in Rule 6.1-1, and I quote, "A lawyer has complete professional responsibility for all business entrusted to him or her and must directly supervise staff and assistants to whom the lawyer delegates particular tasks and functions." End of quote. A lawyer may permit a non-lawyer to act only under the lawyer's supervision. This is regardless of whether the lawyer is a legal assistant, a paralegal, or a designated paralegal. For the purposes of Section 6.1 on supervision, a non-lawyer means an individual who is neither a lawyer nor an articled student. The extent of supervision required will depend on, first of all, the type of legal matter, the non-lawyer's experience and competency, the lawyer's professional and legal judgment with respect to that, and the provision of any relevant statute, rule, or court practice. Rule 6.1-3 sets out what a lawyer must not permit a non-lawyer to do. For example, a non-lawyer must not give or accept undertakings or accept trust conditions, except under very specific conditions. This can be done at the direction of and under the supervision of the responsible lawyer. But it can only be done provided that the fact that the person is a non-lawyer is disclosed, The person's capacity is indicated by their role in the firm, in other words, and the responsible lawyer is identified. In addition, a non-lawyer must not conduct negotiations with third parties other than routine negotiations, and that's only if the client consents and the results in the negotiations are approved by the supervising lawyer before action is taken. In addition, a non-lawyer must not give legal advice or appear in court or actively participate in any formal legal proceedings on behalf of a client, except in a supporting role to the lawyer appearing before the tribunal. Now, turning to paralegals, the second category that I identified earlier, for the purposes of Section 6.1 and supervision, paralegal means a non-lawyer who is a trained professional working under the supervision of a lawyer. A lawyer may employ as a paralegal a trained person working under a lawyer's supervision who has the necessary knowledge, skills, training, experience, and character to perform competently and ethically the tasks that the lawyer delegates to him or her. A lawyer must not delegate work to a paralegal nor hold a person out as a paralegal unless the person has the necessary attributes. Lawyers should be guided by Rule 6.1-3 sub 2 and Appendix E regarding supervision of paralegals. And it talks about assessing a person's competence, experience, and personal qualities, understanding key concepts in supervision, and implementing best practices for supervision and training. Appendix E, which is a new appendix, has a good checklist for assessing the competence of paralegals. While there is no specific limit on the number of paralegals a lawyer is permitted to employ who are not designated paralegals, a lawyer must limit the number of non-lawyers that he or she supervises to ensure there is sufficient time for adequate supervision.
Thanks. Barbara, I understand that there's some special rules for designated paralegals that may give designated paralegals an enhanced role. Can you speak to this for us?
Sure, Wendy, that's right. The Law Society permits lawyers to classify certain paralegals as designated paralegals. We'll cover this only briefly since the Law Society has already put out a lot of information about designated paralegals that can be found on the Law Society website. And there's also an article on this topic by Bruce LaRose, last year's president of the Law Society, and the January 2013 edition of The Advocate. Rule 6.1-2 sets out the definition of a designated paralegal. A designated paralegal means an individual permitted under Rule 6.1-3.3 to give legal advice and represent clients before a court or tribunal. It's up to the supervising lawyer to determine whether a paralegal is classified as a designated paralegal based on the lawyer's confidence in the paralegal's skills and the restriction on the number of designated paralegals a lawyer may supervise. Pursuant to Law Society Rule 2-9.2, a lawyer may supervise up to 2 designated paralegals at one time. As in the case of paralegals, designated paralegals may give or receive undertakings at the direction of and under the supervision of a lawyer responsible for the legal matter, providing that in any communications the fact that the person giving or accepting the undertaking or accepting the trust condition is a non-lawyer is disclosed. The capacity of the person is indicated, and the lawyer who is responsible for the legal matter is identified. A lawyer may permit a designated paralegal with the requisite skills and experience to give legal advice and also to represent clients before a court or tribunal, as permitted by the court or tribunal, of course. As of January 1, 2013, designated paralegals have been permitted to make limited appearances in court to deal with specific family law procedural matters in a pilot project operating until December 31, 2014. This project is currently operating in provincial court in the Surrey and Cariboo Northeast registries and in the Supreme Court in the Vancouver, New Westminster, and Kamloops registries. The court controls the right of audience and the types of appearances that a designated paralegal may be permitted to make. These are primarily non-contentious procedural matters. Some key requirements about court appearances by designated paralegals are that when a lawyer is allowing a designated paralegal to appear in court, the lawyer with conduct of the file is required to provide an affidavit for the first appearance by the designated paralegal, deposing to specifically required content as part of the application material. Also, the supervising lawyer must be available by phone when a designated paralegal is in court, in the event that the court asks that the lawyer be contacted. And if the court is concerned that the designated paralegal is not prepared or competent to speak to the matter, the court may require the supervising lawyer to attend. Lawyers are accountable to the Law Society in the event of a complaint or insurance claim stemming from the work of any paralegal or designated paralegal. More detailed information is available on the Law Society website, and lawyers with questions are welcome to contact a practice advisor.
Barbara, do you have anything more to add on the issue of supervision?
Actually, yes. I'd like to caution lawyers who practice real estate that you must not permit a paralegal or designated paralegal to have access to your digital signature or use it to electronically sign a land title document. It's an offense under the Land Title Act and a breach of juracert terms and conditions to permit anyone to have access to your digital signature or to use it to electronically sign a land title document. So lawyers are required to affix their own digital signature. The Fall 2012 Ventures Bulletin has an article about this for lawyers who would like more information. And there's also detailed information on the juracert website about the Director of Land Titles requirements. Lawyers with questions about juracert that they can't find on the website are welcome to call the Law Society's Member Services Department.
Now, Barbara, what about articled students? Are they covered by the code, and what are they allowed to do?
Sure, articled students are covered by the code. The code applies to students enrolled in the Law Society admission program by virtue of the definition of lawyer in Rule 1.1-1. However, articled students and principals should primarily look to Law Society Rule 2-32.01 for what articled students are permitted to do or not do. Subject to any prohibition in law, the rule states that an articled student may provide all legal services that a lawyer is permitted to provide, but with the exceptions set out in that rule. For example, an articled student must not accept an undertaking unless the student's principal or another practicing lawyer supervising the student also accepts the undertaking. Students may appear as counsel with proper supervision and within the limits of the rule. Supervision does not always mean that the student's principal or another practicing lawyer supervising the student must be in the actual courtroom with the student, but in some cases it does. For example, the student must not appear as counsel on his or her own in an appeal before the Court of Appeal. Further, it should be noted that an articled student is not entitled to take a client's affidavit. This is because of Section 60 of the Evidence Act. Section 60 sets out who are, because of their office or employment, commissioners for taking affidavits for BC. Section 60 sub D permits practicing lawyers, as defined in Section 1.1 of the Legal Profession Act, to take affidavits. Students with questions about what they are permitted to do may contact the Member Services Department. If they have questions about their ethical obligations under the code, they are welcome to contact a practice advisor on a confidential basis.
Great. Now we'll turn to the code's final chapter, Chapter 7, which discusses the lawyer's relationship to the Law Society and to other lawyers. I understand that a lawyer's duty to report is expanded in the code. Barbara, could you speak to this?
Yes, that's right, Wendy. It is expanded. Unless to do so would involve a breach of solicitor-client confidentiality or privilege, Rule 7.1-3 requires a lawyer to report to the Law Society a number of things. First of all, a shortage of trust monies. And of course, separate from the code requirement, reporting a trust shortage is also required by Law Society Rule 3-66. So this isn't anything new. A lawyer must also report a breach of undertaking or trust condition that hasn't been consented to or waived. A trust condition is treated as equivalent to an undertaking in the code. This is set out in paragraph 2 of the commentary to Rule 7.2-1. A lawyer must report the abandonment of a law practice, participation in criminal activity related to a lawyer's practice, the mental instability of a lawyer of such a nature that the lawyer's clients are likely to be materially prejudiced, conduct that raises a substantial question as to another lawyer's honesty, trustworthiness, or competency as a lawyer, and any other situation in which a lawyer's clients are likely to be materially prejudiced. The reporting rule's wording appears to mean that a lawyer is also expected to report himself or herself in all of these situations, with one exception: conduct that raises a substantial question as to another lawyer's honesty, trustworthiness, or competency. That reporting requirement is the only instance where the requirement appears to be limited to reporting another lawyer's conduct rather than an obligation to report oneself as well as another lawyer. Reporting a lawyer isn't something that one should do with malice or ulterior motive. It's a very serious step, and lawyers are welcome to consult a practice advisor for confidential assistance if they are in doubt about whether to report someone. Reporting a lawyer who has departed from professional conduct may uncover a very serious situation, for example, related to emotional disturbance, substance abuse, or criminal activity.
Barbara, could you comment a little bit more about undertakings?
Oh, sure. So we've already discussed undertakings in terms of supervision, so I won't go into that again, but undertakings also come up in some other parts of the code. For example, Rule 5.1-6, Rule 7.2-11, and Rule 7.2-12. Rule 5.1-6 says that a lawyer must strictly and scrupulously fulfill any undertakings given and honor any trust conditions accepted in the course of litigation. Rule 7.2-11 has the same wording as the former rule in Chapter 11 of the Handbook, but with additional guidance set out in 6 paragraphs of commentary to the rule. A lawyer must not give an undertaking that cannot be fulfilled, fulfill every undertaking given, and honor every trust condition once accepted. Undertakings continue to be a concern, and from the calls that we get from lawyers, a problem seems to be that the undertaking was ambiguous, or there was a condition that the lawyer could not personally fulfill. Those seem to be the most common types of calls. Undertakings should be written or confirmed in writing, both the imposing and the accepting of the undertaking. They should be absolutely unambiguous, reasonable, state the time limits within which the condition must be met. That's another problem that we often get on a call. Sometimes there was no time limit set. And finally, the undertaking must be in your control. Paragraph 1 of the commentary says that if a lawyer giving an undertaking does not intend to accept personal responsibility, this should be stated clearly in the undertaking itself. In the absence of such a statement, the person to whom the undertaking is given is entitled to expect that the lawyer giving it will honor it personally. The commentary says that the use of such words as "on behalf of my client" or "on behalf of the vendor" does not relieve the lawyer giving the undertaking of personal responsibility. For a useful article on undertakings, see the article Undertakings in BC Don't Get Buried by Alan McDonnell QC in The Advocate in May 2012. There's some good tips in there, and so I'd encourage you to take a look at it. At this point, I'd also like to mention the rule about meeting financial obligations in relation to one's practice. These are some other kinds of calls we get, and we hear of problems that could have been avoided if it was made clear from the beginning in writing who would be responsible for paying for a consultant, expert, or other professional. The commentary to Rule 7.1-2 sets out guidelines. Lawyers have a professional duty apart from any legal liability to meet financial obligations incurred, assumed, or undertaken on behalf of a client. Unless before incurring such an obligation, the lawyer clearly indicates in writing that the lawyer is not assuming the obligation personally. So when a lawyer retains a consultant, expert, or other professional, the lawyer should clarify the terms of the retainer in writing, including specifying the fees, the nature of the services, and who is responsible to pay. If the lawyer isn't responsible for payment of the fees, the lawyer should help in making satisfactory arrangements for payment if it is reasonably possible to do so. Paragraph 3 of the commentary says that if there is a change of lawyer, the lawyer who originally retained a consultant, expert, or other professional should advise him or her about the change of lawyer and provide the contact information for the new lawyer.
Gavin, are there any rules that you'd like to highlight about the issues of courtesy and good faith?
Yes, there certainly are. Chapter 7 and the canons at the beginning of the code both say that a lawyer's conduct towards other lawyers should be characterized by courtesy and good faith. A lawyer must be courteous and civil and act in good faith with all persons with whom the lawyer has dealings in the course of his or her practice. There are a few points that we'd like to highlight. Personal animosity between lawyers may cause their judgment to be clouded by emotion and hinder the proper resolution of a matter on behalf of the clients. A lawyer should agree to a reasonable request concerning trial dates, adjournments, the waiver of procedural formalities, and similar matters that do not prejudice the client's rights. A lawyer must not take advantage of or act without fair warning upon slips, irregularities, or mistakes on another lawyer's part, not going to the merits or involving a sacrifice of a client's rights. While there's no equivalent to Rule 12 of Chapter 11 of the Handbook in the Code, it is our personal view that a lawyer who knows that another lawyer has been consulted on a matter must not proceed by default in the matter without inquiry and reasonable notice. A lawyer must not record a conversation between the lawyer and a client or another lawyer without first informing the other person of the intention to do so. Now, there's some very good articles on this topic, and that they include Rick Peck QC's article, The Commandments of Advocacy in the Advocate, January 2012, and Rick Sugden QC's articles, Civility in the Legal Profession in the International Society of Barristers Quarterly, and in his essay in The Splendor of the Law, a book of essays in honor of the former Chief Justice Alan McEachran.
Now, there are an increasing number of people acting on their own. What does the new code say about a lawyer's obligations when dealing with an unrepresented person?
Rule 7.2-9 requires that the lawyer must urge the unrepresented person to obtain independent legal representation. Also, take care that the person doesn't think that his or her interests will be protected by the lawyer, and make it clear to the unrepresented person that the lawyer is acting exclusively in the client's interests. Putting this in writing to the unrepresented party may be prudent, or at least keep some evidence in your file that you address the requirements of the rule with the person.
Now, sometimes a lawyer may want to have a business other than just practicing law. Gavin, is this permitted?
Yes, it is, but there are restrictions, and those are covered in Rule 7.3-1. If a lawyer wants to engage in another profession, business, or occupation, Currently, with the practice of law, the lawyer must not allow an outside interest to jeopardize the lawyer's professional integrity, independence, or competence. There are some key points to keep in mind, and they include the following. You have to be aware of the potential for conflicts to develop. It should be either clear to the client when the lawyer is acting as a lawyer and when the lawyer is acting in a different capacity. And in addition, a lawyer should not let his or her involvement in an outside interest impair the lawyer's judgment on behalf of the client. Also, whether or not and to what extent a lawyer may be permitted to engage in an outside interest covers the widest possible range of activities and is subject to any applicable law or law society rule. Some outside interests are easier to separate than others. For example, acting as a volunteer choir conductor may be less likely to cause an issue than a lawyer running a company who wants to sell non-legal services to a client.
Now, I sometimes hear lawyers on the radio or on TV commenting on a client's case. Sometimes it seems okay, and other times I wonder if it's really kind of appropriate. Barbara, what should a lawyer be doing?
Well, there's some good guidance in the code about this. Section 7.5 of the code is the section about making public statements. Before making a public statement concerning the client, the lawyer should be satisfied that it is in the best interest of the client. Also, it should be within the scope of the retainer. And it shouldn't be done for the purpose of self-promotion or self-aggrandizement. And there is no infringement of the lawyer's obligations to the profession, the courts, or the administration of justice. It's really important to keep in mind when making a public appearance or giving a statement that you will normally have no control over any editing that may occur afterwards, or in the context that your appearance or statement may be used, or under what headline it may appear. Before arranging an interview, get the client's consent. Also, be ready for a reporter's approach when you step out in the street after a day in court. Think in advance what you or your client may say, or whether it's better to say nothing at all. A lawyer must not communicate to the media or make public statements about a matter before a tribunal if the lawyer knows or ought to know that the information or statement will have a substantial likelihood of materially prejudicing a party's right to a fair hearing.
I understand that the code sets out a lawyer's professional obligations to inform both the client and the insurer when the lawyer discovers an error or omission that may be damaging to the client. Barbara, do you have a comment on that?
Well, yes, briefly. Questions about insurance coverage and reporting are best answered by the lawyer's insurance fund. That is when you need to report for a possible insurance claim. There are, however, some ethical requirements in the code relating to errors and omissions. Just to refresh people's memory, under the compulsory policy, not in the code, a lawyer is contractually required to give written notice to the insurer immediately after the lawyer becomes aware of any actual or alleged error or circumstances that could reasonably be expected to be the basis of a claim, however unmeritorious. This is condition 4.1 of the policy. The Law Society Rule 3-21 sub 2 states that a lawyer is bound by and must comply with the terms and conditions of the compulsory insurance policy. Then we get to the code. Rule 7.8-2 of the code imposes an ethical obligation on the lawyer to report to the insurer. In addition, as stated in the rule's commentary, a lawyer has an obligation to comply with the provisions of the policy insurance, and the policy requires immediate reporting. This means that the lawyer must report to the insurer first before the lawyer attempts any rectification. And this way, a client's protection from a lawyer's insurance should not be prejudiced because of a late report. A lawyer also has an ethical obligation to the client when the lawyer discovers an error or omission that is or may be damaging to the client and that cannot be rectified readily. The lawyer must promptly inform the client without admitting legal liability, without indicating that the lawyer's insurer will take care of everything. The lawyer must recommend that the client obtain independent legal advice concerning the matter, including any rights the client may have arising from the error or omission. And the lawyer must advise the client of the possibility that in the circumstances, the lawyer may no longer be able to act for the client. Please contact the Lawyer's Insurance Fund if you have concerns about a possible claim, even if you think it's unmeritorious. If you are not sure who to contact, you're always welcome to contact a practice advisor who can either help you or refer you to the relevant department, the Lawyer's Insurance Fund.
All right, this brings us to our second question period. Thank you for all of your questions. Now, there's quite a bit of discussion on the chat feature about the commentary versus the rules. So Barbara, let's address this in front of everybody. Are the commentary and the code rules given equal weight?
Thanks, Wendy. I did talk about this in the beginning. It's our view that the rules and the commentary are of equal weight. We think this is something that will be looked at by the Ethics Committee in the first half of 2013. To answer part of somebody's question around this, the Ethics Committee did not write the commentary. The commentary is based on the model code, so you'll find the commentary in the model code. Occasionally there may have been some slight changes in BC in the commentary to reflect BC needs. Anyway, I hope that answers your question. Gavin, did you have anything to say about that?
Yes, the commentary is really there for purposes of explaining the implications and the effect of the rule. So it's an elaboration on the rule, and that's why I'm of the view that it does in effect carry equal weight to the rule. It really explains how the rule is to be applied. That's one of the reasons for the commentary. It also has examples in some of the other areas of the commentary. I know that the Ethics Committee will be looking at that in the next several months. It has been the subject matter of discussion in other jurisdictions, including comments from decisions of benchers in the Law Society of Upper Canada, and I believe the courts, and will be reviewing that jurisprudence. But in terms of, as I understand what the objective is with respect to commentary, it is to elaborate in a meaningful way, in a more complete way, in a more fulsome way on the effect of the rule. So I think that's the way, certainly the way I presently view it, but as I said, the Ethics Committee, as I understand it, has this very much on their agenda. We'll look at the jurisprudence from the other jurisdictions and how the other law societies have dealt with, particularly the Law Society of Upper Canada, has dealt with this topic, because after all, the structure that we now have, which as I said earlier, I think is a much better structure, is a structure that the Law Society of Upper Canada has had for many years.
All right, thank you. We certainly hope that that answers most of your questions on this topic. In the handbook, there were specific rules about contacting an opponent's expert. Gavin, I couldn't find one in the BC Code. Am I missing that?
No, that topic is, or that matter is not now dealt with in the new BC Code of Professional Conduct. We start with the proposition that there's no property in a witness. The general rule about interviewing witnesses is dealt with in Rule 5.3, and you can seek information from potential witnesses, whether they're under subpoena or not, but you must disclose, as we discussed, the lawyer's interest, and take care not to subvert or suppress any evidence or procure the witness to stay out of the way. This, of course, is subject to the rules on communication with a represented party that's set out in Rules 7.2-4 to 7.2-8. So there isn't any specific provision that deals with it as there was in the handbook. And I think the point to be made is that the objective of the Federation and the objective of the law societies, who are obviously the guiding hands of the Federation, is to develop a model code, develop a consistent code of ethics across the country. And the mobility rule is one of the main drivers with respect to this. And of course, part of the mobility rules or the agreements that we've entered into across the country means that lawyers, litigators regularly come into our province under the temporary transfer rules, as well as moving into our province on a permanent basis pursuant to those rules. And so it's very desirable to have a consistent approach across the country to matters such as this. And so the Ethics Committee will be looking at this topic, but in looking at it, they're going to have to consider whether we should have a rule that's unique to British Columbia, or should we remain consistent with what the other law societies are doing in the same area.
Thanks, Gavin. So Barbara, can a designated paralegal sign a lawyer's statement of account to the client?
Well, yes, but there's quite a difference between issuing an account and signing an account. So I'd like to elaborate on that a little bit. The lawyer must issue the account. A paralegal or designated paralegal, legal assistant could certainly do a draft of the statement of account, but the lawyer must review the account and approve it. And then the lawyer has to determine what they're going to charge the client and whether the bill is correct and so on. When the bill is actually sent out, and I just want to mention that's in the supervision section in the BC Code in Chapter 6. So it would be in Rule 6.1. There's a list of items that a non-lawyer must not do, and that's in that list. They must not issue a statement of account. There is, however, in the Legal Profession Act, a section in Section 69, it might be sub 3, you'd have to check, but Section 69 sets out a provision about actually signing an account, and a lawyer or a non-lawyer may sign the account on the lawyer's behalf. So I'd encourage you to read that section in Section 69 and understand the difference between that and the must-nots in the supervision chapter around bills.
All right, we had a specific question that says, could a common law solicitor called to the bar in England and currently in good standing with a number of years of actual practicing fall within the definition of a designated paralegal prior to articling student status? Gavin, do you have thoughts on that?
Yes, I do. And I think the simple answer to that question is yes. The whole structure of our designated paralegal involves a decision to be made by a lawyer as to whether or not the individual has the skill and knowledge and ability to do the work that is provided that a designated paralegal can engage in. So it's an assessment by the supervising lawyer. So assuming you deal or meet the obligations with respect to supervision and you form your considered judgment that the individual has the necessary skill and ability, I think the individual can be a designated paralegal until he or she commences their articles. If there's any concern about this, the appropriate person to contact at the Law Society is Leslie Small.
Thanks, Gavin. There was another question that asked, in 4.3-0.1, is there a definition or guidance for the word regularly? Barbara, do you have thoughts on that?
Sure. That rule would be in the marketing chapter, and I think that's to do with regularly practicing in the field of law, in which they wish to state a preference. There's no definition of regularly. It would depend on the facts. If someone has done one case ever in marine law, I think couldn't say they regularly practice in that area. Even if they would like to make that their primary focus, they would have to spend some time practicing in the area to be able to say they regularly practice. Thanks.
All right, I have another question for Gavin. If a client directs their bill to be addressed to a third party for payment, and the third party consents, can the bill be rendered to the third party, or does it need to be rendered to the client?
My view is that the bill should be rendered to the client but sent to the third party for payment. So the bill should reflect who the client is, that it's a bill for that client, but send it off to the third party for payment of the bill.
All right, and I have one final question before we sign off. We're almost on our time. And it asks, how many other provincial law societies are adding the other charge obligation by way of commentary?
Why don't I attempt to answer that question? As I think I said earlier, 6 provinces have now adopted the model code, and the other provinces and territories are actively looking at it with a view to working towards the adoption of the model code. And as this process has gone on, I've been kept apprised of where there are differences being proposed by the various law societies, because that's part of the role the Federation is playing under the auspices of the Standing Committee. It's not been drawn to my attention in any of those law societies who adopted the model code, or any that are looking at adopting it going forward, that they've raised this issue, that they've identified a problem. So my understanding is, subject to reviewing obviously all of the provinces' actual adoption, that 6 of them have already adopted this same approach, and the others, as best as I can ascertain, are going to do the same.
All right, we have come to the conclusion of our time frame. I just have a couple of quick concluding comments before I let you all sign off. Just a reminder that today's session counts for 1.5 hours of both general and ethics CPD credit. You can go online onto the Law Society website and sign yourself in to apply for your credits. Sometimes there is a small delay. It could be several hours, or at most until tomorrow morning before that shows up. Do look for this particular session. There will be a separate session for this date and session number on the Law Society's website to sign up for your credit. Also, if you did not get your questions answered, we know that we had piles of them. You are a very good participatory group. We appreciate all of your questions and comments. Barbara will be dealing with a lot of them in her Practice Watch column in the Benchers Bulletin. Also, you are free to contact a practice advisor to get your specific matters answered for you. It is confidential, and we do have people standing by who can answer your questions for you. Now, on behalf of the Law Society and CLEBC, we'd like to thank you all for joining us for today, and hope that you enjoyed our CLETV broadcast on the new Code of Professional Conduct. Thank you.